Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
A father was charged with child abuse for subjecting his two minor children to both physical and verbal abuse from 2017 to 2018. He hit his daughter with a wooden beater, pulled her hair, struck her with a wooden rod embedded with a nail, kicked his son, and hit him with a dustpan to discipline them for what he deemed were their misbehaviors, such as failing to eat lunch and losing money from their coin bags. Both the Regional Trial Court and the Court of Appeals found the father guilty of violating Republic Act No. 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. Under Section 3B of RA 7610, any act that debases, degrades, or demeans a child's dignity constitutes child abuse. The father appealed to the Supreme Court, arguing that he had no intention of harming his children's dignity. He maintained that the intent to debase, degrade, and demean the intrinsic worth of his children was not proven. Can excessive discipline, which sometimes result in physical injury, be considered outright as child abuse? Hi, I'm Atty. Mike Navallo, Supreme Court Chief Communications Officer. It's the 14th of February 2025, and today we talk about child abuse resulting from excessive discipline that harms or undermines a child's dignity. This in the context of the case of XXX versus People, GR number 268457, decided by the Supreme Court on July 22, 2024. It's an en banc decision penned by Associate Justice Jhosep Y. Lopez. Joining us to talk about this case is Judge Maria Josefina G. San Juan-Torres, Professorial Lecturer and Member of the Philippine Judicial Academy Departments of Special Areas of Concern and Family Law. Hi, Judge Joy. Thanks for joining us. Welcome to the Supreme Court Podcast.
Thank you, Attorney Mike. I'm honored and glad to have been invited to join you in this podcast today.
Our pleasure, Judge Joy. So in this case, this is GR number 268457, the case of XXX versus People. The Supreme Court found petitioner XXX guilty beyond reasonable doubt of 3 counts of child abuse under Section 10A of RA 7610, and he was sentenced to suffer the indeterminate penalty of 4 years, 9 months and 11 days of prisión correccional as minimum, to 6 years, 8 months, and 1 day of prisión mayor as maximum for each count. For the benefit of our listeners, let's talk about RA 7610. What is the law about, and what is the Section 10A?
Now, RA 7610 is a special protection against children against abuse, exploitation, and discrimination. And under Section 10A of RA 7610, it refers to other acts of neglect, abuse, cruelty, or exploitation and other conditions prejudicial in the child's development. Mm-hmm. And in Section 10A of RA 7610, any person who shall commit any other acts of child abuse, cruelty, or exploitation, or be responsible for other conditions prejudicial to the child's development, including those covered by Article 59 of PD 603 as amended, but not covered by the revised penal code as amended, shall suffer the penalty of prisión mayor in its minimum period. Mm-hmm. But when we talk about Section 10 of RA 7610, we have to correlate it with the Section 3B of RA 7610, mm-hmm. which refers to child abuse as that of any maltreatment, whether habitual or not, of the child. And under Section 3B, it enumerates the different acts of child abuse or maltreatment.
Right, and there are about 4 acts here, Judge, that are enumerated. This ranges from psychological and physical abuse. There's also unreasonable deprivation of basic needs, and failure to give medical treatment to an injured child. Right. That can be considered child abuse. But the section that we're talking about, at least this subsection, is any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. This might not sound so concrete to average listeners. How do we determine this element? When you say it debases, degrades, or demeans the intrinsic worth and dignity of a child, how is this manifested usually, Judge, in the cases that you handle?
All right. If you if you read Section 3B of RA 7610 in relation to Section 10A on other acts, you mentioned a while ago that it says any acts by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of the child as a human being. So here you're looking at a specific intent. So an intent to demean or degrade the dignity of a human being, and in this case, the dignity of a child. So that's where this case that you mentioned a while ago, which was penned by Justice Josep Lopez, that it was explained there on how a specific act of debasing or demeaning the dignity of a child becomes one that falls under Section 10 on child abuse.
How do we determine the specific intent, Judge? Because at least to our listeners, if you talk about specific intent, you necessarily have to look into the mindset of the person doing it. But that's something that cannot see outright. So we have to look at the acts. So how do we determine if a certain act has a specific intent to debase, degrade, or demean, as opposed to say, this is a disciplinary measure, maybe spur of the moment, that because you wanted to discipline a child, so you therefore hit the child, or do a physical means of disciplining the child. So how do you delineate? How are you able to determine that?
All right. When we talk about a specific intent here, like you mentioned a while ago, a spur of the moment, like once it can be at the heat of the anger,
Yes.
on the part of the offender or perpetrator. But when it becomes not just once or twice, and there is now, you have to determine that there is a clear intent or purpose of that offender or perpetrator to demean or degrade the dignity of the child, and that's when it falls under Section 3B as in relation to Section 10 on child abuse. So in reality, it's true that we as parents, we have the prerogative to discipline our child. But when it becomes excessive, or when it is not commensurate to the alleged misbehavior or misconduct of a child, to the extent that it is violent, excessive, and debasing, then that constitutes now child abuse under Section 3B in relation to Section 10 of RA 76.
So in short, when you go overboard in disciplining your
Right.
children, that can be and might be considered child abuse already.
Yes, yes.
Now, in this case, Judge, what were the acts that the court considered to have gone overboard, or to have indicated that there is that specific intent? Because in our introduction, we did mention a few of these specific acts.
Right.
Are these acts, when we talk about, let me just go back to some of the things that we mentioned, hitting the son with a dustpan, kicking the son, or hitting the daughter with a wooden beater, pulling her hair, striking her with a wooden rod embedded with a nail. Are these acts overboard? If these acts are done, can we now presume that there is child abuse?
Yes, the Supreme Court was very clear. No? It enunciated in that ruling how these acts were considered to be that there was really a specific intent of the perpetrator, the father in this case, to demean or debase the children who were minors. In this kind of setting, it appears that the mother does not live with the father and the children. So the children, who, although they were minors, they were living with the father, who was running then who was a former seafarer, but then after that he was jobless, and then he set up a sari-sari store, and he was manning the sari-sari store. So in that incident involving the daughter was supposed to bring a lunch for the father, and but it turned out that the father discovered that the daughter did not take her lunch first before bringing the lunch of the father. So the father reacted and hit the daughter with that wooden beater, and that wooden rod had a nail embedded on it. So, and it wasn't only once, but it turned out that he hit the daughter on the right thigh, at the back, and on the right arm. So it wasn't just once, it was thrice. And it was because of the alleged, it wasn't actually a misbehavior, it was just because that the daughter failed to or did not eat her lunch before bringing the lunch of the father. So you will see here, if you would look at the, you would compare the extent of the force or disciplinary measure that was used or undertaken by the father, and the act, the alleged behavior of the child, which to the mind of the court is not actually a misconduct. It's just that the child failed to take her lunch before going to the sari-sari store to bring the lunch of the father. So it is not just excessive, but it is not commensurate to the alleged misbehavior of the child. So in that instance, then the Supreme Court ruled that, in fact, there was a specific intent to demean or degrade the dignity of the daughter. With respect to the daughter was, the father pulled her hair and kicked her. Whereas with the son, he hit the son with a dustpan.
Yes.
And not just once, but several times. And in the course of the trial, the children were very consistent when they testified on how all these incidents happened. And including the fact that they sustained injuries because they had to, after those incidents, they ran away and went to their mother. And it was their mother who brought them for a medical examination because of the injuries sustained by them due to the beating that they received from the father.
Judge, how important is this element of specific intent to debase, degrade, or demean the intrinsic worth and dignity of the child? What if there's no specific intent? What happens then? Will it not fall under 7610? Which law will it fall under?
All right. We have to make a distinction because in RA 7610, in Section 10, it says that other acts that tend to debase, other acts of neglect, abuse, cruelty, or exploitation, and other conditions prejudicial to the child's development. So if you will see in Section 10A, it says that, but not covered by the revised penal code. So in this case of Briñas versus People, the Supreme Court mentioned there that it requires for an act to fall under Section 10A in relation to Section 3B2 of RA 7610, it requires a conviction that specific intent on the part of the offender to debase, degrade, or demean the intrinsic worth and dignity of a child as a human being. Now, this was first established, a specific intent was first established in Bongalan versus People. And in that case, the accused was then charged for striking and slapping the face of a minor under Section 10A of RA 7610. What the perpetrator did was to laid his hands against a child, done in the spur of the moment and in the heat of anger. But in this case, in Bongalan versus People, that spur of the moment and the heat of anger will not constitute child abuse under Section 10. Because as we discussed earlier on, there must be a specific intent. So at the heat of anger or at this spur of the moment does not constitute specific intent. So in that case, if it is only at the spur of the moment or because of a heat of anger, then instead of the act constituting child abuse under 7610, the perpetrator was charged under the revised penal code for slight physical injuries. So that's where you make a distinction that if there is specific intent, it is something that is excessive, something that is really violent, something that is not commensurate. The disciplinary measure that was used is not commensurate to the alleged misbehavior or misconduct of the child. And to the extent that it demeans or degrades the intrinsic worth and dignity of a child as a human being.
So is it a factor, Judge, if, say, it just happened once and you can really say it's spur of the moment, as opposed to repeated beatings over time, then you can establish a pattern perhaps that this is not just spur of the moment.
Yes, that's a factual consideration that has to be looked into when determining whether there is specific intent or not. Because as we discussed earlier on, if specific intent is established, then that falls under RA 7610, under Section 10. If specific intent is not sufficiently established, then the perpetrator can be charged under other acts outside of RA 7610. So it may be under the Revised Penal Code or under RA 9262.
Which is the Anti-Violence Against Women and the
Yes.
Children Act. All right, which we'll discuss in the next
Right.
podcast. And Judge, it appears from this case that it's really important to look at the facts, what happened.
Right.
And judges are in the good position to determine if the children are telling the truth, if it's a father is telling the truth. So in your experience, Judge, what do you look for when hearing testimonies of, say, children complaining of child abuse against the parents?
For me, probably it comes with training and experience when you observe the demeanor of the child and the reaction of the child, and also the witnesses. So the father testifies and the children testify. For a child, if a child, sometimes you can see the trauma. When the child testifies, that the child may be affected by having to recall, especially very sensitive and traumatic incidents. So what I do is, of course, as much as possible, you give an environment that the child is relaxed and give some kind of reassure them that they only have to tell the truth. For us judges, we have to be patient and we have to be very sensitive when the child is testifying. What I do is, if I feel that the child's a little bit fidgety, I talk to the child first and together with the court social worker to determine if the child is ready to testify or is ready to continue his or her testimony. I always have a box of toys and crayons with me, just for the child to be able to, if the child needs some kind of distraction, or at least it's not to spoil the child, but really to make the child feel that he or she is welcome and relax and is here just to tell the truth and give the child the time to relax.
Yes, and just for the benefit of our listeners, you are in a position to say this because you're a family court judge, right, here in Rizal. And so all this experience of handling these cases, when you're reading the case, Judge, I mean, you would really look at whether the court found the testimonies of the children to be clear, positive, and categorical. In those cases, the Supreme Court really will have to rely on the judgment of the judge handling the case.
That's right. And it's always reflected in the transcript of stenographic notes. Sometimes, like if the child feels that the child is intimidated by the questions, as a judge, you can sort of interpolate and make clarificatory questions that is easier for the child to understand. And you will see that if the child is consistent and is firm with the answer, then the child is telling the truth. It comes with probably experience and the practice of being sensitive to the expressions, the reactions, the body language of the witness, and in this case of a child witness, whether the child is telling the truth or not, and providing for a safe space where the child can testify. So in this case, we adjust with whatever resources we have, as long as we are able to provide a safe space for the child. So if the child would want some kind of privacy, the child can testify in the chambers, and I call both lawyers,
Mm-hmm.
the prosecution and the defense to be there.
Mm-hmm.
And if the child needs a guardian or a court social worker who will not testify,
Mm-hmm.
who will not be a witness for any of the parties, to be with the child, just to have some kind of a sort of to add to some kind of support for the
Support,
child while the
yeah.
child is testifying.
Yeah.
And then, of course, practice is we don't wear our robes in front of a child.
And why is this, Judge?
Well, there was jurisprudence and there were some reactions from litigants that the children sometimes feel that it is intimidating to see somebody in a robe.
I see.
Although, of course, generally a robe is some vests authority on the
Yes.
judge. But in this case, for children, it may have a different impression on them,
They put them off.
right? So they feel like it's kind of intimidating.
Yes.
So in order to give, again, that environment of a safe space for them, if they feel more comfortable that the judge is not wearing a robe, then we don't wear a robe when a child is testifying.
And I'm just curious, Judge, child abuse cases under RE 7610, how often does this happen, at least based on your caseload right now? Do you see a lot of child abuse cases?
This is not based on statistics, but on my personal
Yes.
observation is that after the pandemic, there is really a surge of child abuse cases. And to the extent of some like rape cases and even incest. It's a spike. A spike of child abuse cases. So, to my mind, I think that is something that we should look into. Is it because of the effects of the pandemic that families had to be enclosed, had to live in one, and due to the lockdown, that families were constrained from going outside?
Right.
And especially for those in grassroots communities, that they have to be in cramped shelters or cramped houses. Is it because of the effect of social media? So probably that's something that we should look into beyond the statistics or numbers as to why there is this spike.
Yes.
The social cultural aspect of it, the economic aspect of it as well. So that's
Right.
just my observation.
Right. And it's certainly, we should certainly look into that. But just to close this discussion, Judge Joy, what's our takeaway, especially for parents who may have the tendency to, say, go overboard in disciplining their children out of, say, frustration or anger? What's a good advice to them? I mean, being a parent yourself, what do you say to parents so that they don't go overboard and commit child abuse?
I understand that sometimes we have bad days, and sometimes we get so stressed up. And it's just human for us to lose our temper once in a while. But when it comes to disciplining children, we always have to take a step back and weigh things, and as much as possible to avoid any act that is violent, any act that is excessive on the supposed misbehavior or misconduct of the child. As a parent, it's always good to level off with the child and talk to the child and explain first what was the act and why is it supposed to be wrong, and why it should not happen again. But not to act on impulse and and I think parents should change their mindset that the only way to discipline the child is to do a violent act.
Thank you very much,
That
Judge.
should be the last resort.
Yes, thank you very much, Judge Joy. And of course, we will still have you for the next episode. This time we'll talk about violence against women and their children and the interplay between this law that we're talking about here, RA 7610, or the law against child abuse. But for now, thank you for joining us, Judge Joy. If you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for the case of XXX versus People, GR number 268457. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
This week at the Supreme Court. The Judicial and Bar Council, or JBC, has announced the opening for application or recommendation of the position of Supreme Court Associate Justice to take the place of Honorable Mario V. Lopez, who will compulsorily retire on June 4, 2025. The deadline for the submission of online applications through the JBC online registration and application system is on March 28, 2025 at 4:30 in the afternoon. The Court en banc in Bar Matter number 4261 has ordered to defer the implementation of the prohibition on government lawyers from becoming chapter officers of the Integrated Bar of the Philippines, or IBP, for another term or until 2027. This prohibition is stated in Section 4 of the IBP's revised bylaws. The court emphasized that government lawyers are prohibited from serving as chapter president and from holding more than half of the total officer positions in IBP chapters with no more than 100 members. But the following government lawyers are still prohibited: presidential appointees, national government or government-owned and/or controlled corporations officers with salary grade 26 and above, local government unit officers with salary grade 25 and above, elected officials, prosecutors, and those employed in the judiciary or quasi-judicial bodies. The Supreme Court has ruled that officers and directors of electric cooperatives are not automatically deemed resigned upon filing their certificates of candidacy, or COCs, for local and national elections. In a decision written by Associate Justice Jhosep B. de Maampao, the Supreme Court's Third Division nullified Section 2 of National Electrification Administration, or NEA, Memorandum Number 2012-2016, which mandated that officers of electric cooperatives be deemed resigned upon the mere filing of their COCs. Under the Omnibus Election Code, automatic resignation upon filing of COCs applies only to persons holding public appointive positions, including active members of the Armed Forces of the Philippines and officers and members of government-owned or controlled corporations. This ruling stemmed from a case filed by Oscar C. Borja and Venancio B. Regulado, former members of the Board of Directors of Camarines Sur Electric Cooperative 2, who challenged the validity of Section 2 of the NEA Memorandum. Borja ran for mayor of Bombon, Camarines Sur, while Regulado sought a seat in the Canaman Municipal Council. In another case, the SC has emphasized that a contract of sale of goods is completed by a mere agreement between the parties, even without a written document. In A Ponencia by Associate Justice Henry John Paul B. Inting, the SC's Third Division directed Marcelina Villanueva to pay Coca-Cola bottlers Phil's Inc. over 600,000 pesos for unpaid products delivered under their dealership agreement. Coca-Cola claimed it had a dealership agreement with Villanueva, but she denied knowledge of the dealership agreement, claiming it was her nephews who actually managed the business and that they should be held liable instead. Ruling that Villanueva is liable to Coca-Cola for the entire unpaid obligation, the Supreme Court held that while no written contract was presented, the sale of goods was proven through other evidence, such as signed delivery invoices confirming the purchase, payment terms, and actual delivery of the products. The Supreme Court has also reiterated that a notice to cancel a contract to sell real estate must be notarized under Republic Act No. 6552 or the Maceda Law. In a decision written by Associate Justice Antonio T. Go Jr., the SC's Second Division upheld the validity of contracts to sell between State Investment Trust Inc. or SITI and spouses Carlos and Victoria Baculo after SITI failed to meet the Maceda Law's cancellation requirements. SITI had sold 2 parcels of land in Batasan Hills, Quezon City to spouses Baculo through 2 contracts to sell, payable in installments over 3 years. When they failed to complete payments, SITI sent letters demanding payment within 5 days, and later declaring the contracts to sell cancelled. The spouses refused to vacate the property, leading SITI to file an ejectment case. The SE ruled that while a seller may cancel a contract to sell under the Maceda law on its own without going to court, it must still comply with Section 4 of the law, which requires number 1, a 60-day grace period for the buyer to settle overdue installments counted from the date the installment became due. Number 2, a notarized notice of cancellation from the seller. And 3, cancellation only after 30 days from the buyer's receipt of the notarized notice. In another case, the SC has ruled that only injured or aggrieved spouses can ask the court to nullify their bigamous marriage and guilty spouses cannot do so. The SC en banc, through the ponencia of Associate Justice Ricardo R. Rosario, denied a Filipina's petition to declare her second marriage void for being bigamous. The petitioner had married a Chinese national in Hong Kong and in the Philippines, and later married a Filipino when she came back home. The first husband secured a Hong Kong divorce decree, which was recognized by a Parañaque court. After 14 years, she and her second husband separated. In her petition before the SC, she argued that since her first marriage is already annulled and her first husband had already passed away, she is now the only party who can file the petition to void the second marriage. The SC denied her petition, emphasizing that the purpose of invalidating a bigamous marriage is to protect an existing legal union, not to end it. Since her first marriage had already ended, there was no legal union to protect and no reason to dissolve her second marriage. Article 35, paragraph 4 of the Family Code states that bigamous marriages, or those entered into while one party is still legally married to another, are invalid from the beginning. Under the rule on declaration of absolute nullity of void marriages and annulment of voidable marriages, only the spouses may petition to invalidate a void marriage. Such spouse must be the injured or aggrieved spouse, as clarified in the rationale on annulment of voidable marriages and declaration of absolute nullity of void marriages, legal separation, and provisional orders. Meanwhile, Chief Justice Alexander G. Hismundo led the Philippine Judiciary Delegation to the 2025 Pacific Judicial Conference from February 9 to 12, 2025 in Auckland, New Zealand. He was joined by Supreme Court Associate Justices Ramon Paul L. Hernando, Rodil V. Zalameda, Mario V. Lopez, Samuel H. Garlan, and Jose Maidas P. Marquez. During the conference, Justice Marquez discussed the benefits and challenges of technology, including the role of artificial intelligence, or AI, in the work of the Philippine judiciary. Titled Strengthening the Institution of the Judiciary, the conference gathers judiciary leaders from 15 Pacific Island nations, Singapore, Australia, the United States of America, and the United Kingdom. The Supreme Court, led by its Committee on Gender Responsiveness in the Judiciary, or CGRJ, also held a kickoff activity on Monday in support of the 2025 1 Billion Rising Global campaign, reiterating its commitment to ending all forms of violence against women, or VOW. Themed Rise for Freedom, a short program was held after the flag-raising ceremony. Acting Chief Justice Marvic M.B. Leonen and CGRJ co-chairpersons Associate Justice Henry John Paul B. Inting and Associate Justice Josep Y. Lopez delivered inspirational messages encouraging SC officials and personnel to speak out and do their part in helping fight violence against women. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast at the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, Victor Laranio, Lawrence Olanio as sound editors, and Tyke Flores and Jerome Batumalake as web editors.